accident, you know what probably would have ended up happening? You were to survive, you would have been just fine. The people who are usually not intoxicated, who are hit by an intoxicated driver, their life is usually changed forever because either they end up dying or either they end up having significant injuries. Don't drink and drive. And I know that nobody ever goes to a restaurant or goes out and says, you know what, let me take some drinks. Please whisper. Court is calling 2023 CR 10492, State of Texas versus Rene Rodrigo Esparza. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Tim Roundtree.
Are you Mr. Esparza?
Yes, ma'am. Yes, Your Honor.
Counsel, have you received all the discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Esparza, I'm going to show you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Esparza, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged while driving while intoxicated, third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, sir.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea today?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Esparza, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. State recommends community supervision. There's to be the DWI intervention course, DWI VIP, driver safety course, regular UAs or an alcohol patch, 2 years driver's license suspension and ignition interlock for half the term. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, sir.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea. State is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation, 250 hours of community service restitution, GPS in lieu of the 10 days in the Bexar County Jail. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
Any objections?
No, Your Honor.
All right, state, you may continue to confer.
Thank you.
Mr. Esparza, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and submitted and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I just ask that you would follow the agreement. Mr. Esparza understands the seriousness of this offense and is committed to sobriety and moving forward, complying with all the terms of probation. And I believe he's not going to have any problems.
All right, how old are you?
45, Your Honor.
So what type of vehicle was it?
It was a 2020 Lexus.
You know, I've heard of people, although it shouldn't be done at all, I've heard of people saying, oh, I want to try out my new car. And maybe it's a Lamborghini, maybe it's an Aston Martin, but I've never heard of people trying out a Lexus at over 100 miles per hour. I mean, you could have killed many people. You understand?
Yes, Your Honor.
So what do you do for a living?
I actually appreciate weddings. I have 2 wedding companies. Me and my wife have built for the past 11 years together.
All right. You know that while you're on probation, there's no drinking of alcohol. And based upon your history, you're one of those people who can't just drink 1 glass and be done. So it's probably best for you in your future, even if you successfully complete this probation, which you should be able to successfully complete it, that you don't drink at all. All right. This is what the court is going to do. Court is going to sentence you to 6 years in the prison, suspended and probated for 6 years. There's a $2,000 fine that will be probated. DWI intervention course, DWI education course, DWI victim impact panel live, a driver safety course, random regular UAs, 2 years driver's license suspension, ignition interlock for half the term, proof of employment within 30 days, no employment as a home health care provider or with minors, regular reporting by Zoom or in person, 90 sober meetings in 90 days, TAP evaluation out of custody, and do a referral to felony drug court. There'll be 250 hours of community service restitution. And he can buy out of those if he chooses at $7.25 per hour. Field visits 1 time per month for 3 months. Then at probation's discretion. All right, with regards to the GPS in lieu of the 10 days in Bexar County Jail. If you only want to have the GPS for 10 days, then that's full house arrest. That means you will not be allowed to leave your home. So do you want it for the full 10 days?
Yes.
All right, so there's to be full GPS for 10 days in lieu of the Bexar County Jail. Probation, is there anything else he needs?
Okay.
All right. And with regards to the TAP evaluation, follow the TAP recommendations. Of course, if it recommends inpatient treatment, we'll start with intensive outpatient treatment. Is there anything else you need from the court to be successful?
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
Off the record, here's the thing. Usually when people are driving intoxicated and you going 100 miles per hour, if there would have been an accident, you know what probably would have ended up happening? You were to survive, you would have been just fine. The people who are usually not intoxicated, who are hit by an intoxicated driver, their life is usually changed forever because either they end up dying or either they end up having significant injuries. Don't drink and drive. And I know that nobody ever goes to a restaurant or goes out and says, you know what, let me take some drinks and go out and kill somebody or go out and have an accident. Nobody is anticipating that. I don't know why, when people are planning to drink and you know you're going to drink, I don't know why people just don't have a designated driver. I personally don't drink alcohol. I think it tastes nasty. So throughout my education and even now, I'm always a designated driver. It results in me having free soda, free lemonade, sometimes a free meal. But people know Stephanie's the designated driver. So be better, okay?
Yes, Your
And thank you for dressing appropriately for court. All right. So what we're going to do is I'm going to reset you, okay? Because my understanding, you still need to speak to someone. So I'm going to give you a different court date. And counsel, I'm going to set it for April 1st. And if something comes up sooner, then we'll do it sooner. So let me give you a reset form. And then once he signs it, you all excuse. You're welcome. Yes, I will. If you'll have them print a B page and I'll ask that be waived.
Yes, so what do you think about that? Yes.
Okay. Okay. Counsel, I know you've just recently been appointed.
That's correct, Your Honor. And I was looking into one matter last time. We got that question resolved, I believe.
Mhm.
But I do need one more reset before we can be ready to go.
Okay. Let me look here. February 8th, is that enough time?
Check real quick.
And it will be it's for the plea deadline date.
If I'm not in trial, February 8th is fine.
All right, February 8th is going to be your plea deadline date, Mr. Arnett, and you need to make sure that you're on time for court. You understand? Yes? Okay. All right, once you sign the reset form, you're excused.
Have a seat. I'll give it to you in a second.
So you've hired an attorney, correct?
Yes,
Okay. And you filed a notice?
I have, Judge.
Right. So where are we on discovery?
I'm missing some discovery, which is not a surprise on this first setting. I've sent an email to Hank about it and I've asked for an offer, so we're just gonna wait and see about that.
All right, so what discovery are you missing?
I am missing I believe the IDR, at least one Coban. And I don't know off the top of my head, but I took an inventory of it.
Okay. All right, I'm gonna recall this for February 26th, and that will be for discovery.
And if Ms. Warburton is gonna file a breath or blood, does she file that today, Judge?
Yes.
Oh, yes, I will file that when I get back to my office. Thank you for reminding me, Hank. Instead of the 26th, Judge, could it be the 29th? I have a doctor's appointment on the 26th and the 27th and the 28th.
All right, we'll put it for the 29th.
Thank you, Judge.
All right. So where are we on discovery?
Your Honor, as regards Mr. Flores' case, I believe all discovery that the state is aware of is uploaded into his file evidence repository. I have also, as there are co-defendants in this matter, there's a discrepancy between what Mr. Flores has available and his two co-defendants. I've already brought that up to counsel. We are working on a solution to it where I will personally give everyone everything by copying what I've downloaded and been working with to date. And one firm has provided me a hard disk to provide a copy. The other one will get me one today, and we will make that available to all parties equally by the end of the week.
All right. Your reset date for discovery is going to be February 26th. At that time, all discovery needs to be in.
One other issue that state is still working on, Your Honor. The deceased complainant in this matter had a treatment period at Starlight Recovery in Kerrville. I've made efforts to obtain those documents. They are now bumping me back as a federal HIPAA violation. I anticipate it's taking the state some time to work through that. I'm not saying I won't have it by the February 26th date, but I am attempting to bring it to the court's attention. We expect the deceased mindset to be an issue at trial, and so that is why we're trying to proceed aggressively to get those documents from the treatment facility.
All right. So they've been subpoenaed.
Yes, ma'am. And
Okay.
they're rebutting the subpoena, so we're trying to work it out.
All right. Anything else other than the complainant's medical records?
Judge, from the defense, just for the court's consideration on the given February date, we're going to work within those parameters. But there's the possibility that it might not be complete by then. Between the last discovery volley and this one, it's gone from 800 items to 1,394. So to be able to appropriately review all these things and decide what is or isn't missing still, it's going to take a considerable amount of time.
And are you the only attorney who knows that it's 1,394? Will the other attorneys know that as well?
They will know that number as well.
Okay.
It's 1,394.
Actually 1,377, but defendant Flores is the one that got that matter. The other two have somewhat lesser amounts, which is why I'm going to equalize it to all.
All right. So you're telling me that everybody is going to have everyone's discovery.
Yes, ma'am.
All right. We'll come back on February 26th. That'll be discovery at
Thank you,
9
Judge.
a.m. Once you sign the reset form, you are excused.
Yes, ma'am.
Thank you. Thank you, Judge.
For whatever the reason, is off by over 100 PDF documents. And that, when I noticed it, and coordinated with all counsel by email, that's why I'm going to equalize across all three.
All right. Your reset date for discovery is going to be the 26th. And we'll see where we are.
Yes, Judge. And there's one other matter. I've conferred with counsel with the state. There's a motion to amend bond conditions for Mr. Villalobos to travel to get some diagnostic testing from an accident he had prior to this incident when he was on duty.
All right.
And we
Just
have-
give me one moment. Let me write this down and then we'll take that up.
Sure.
All right. And we're going to go on the record. Court is calling 2023 CR 11510C, State of Texas versus Nathaniel Villalobos. Could I have parties announced for the record for the state?
Darrell Harris for the state, Your Honor.
Defense?
Nico LaHood from Mr. Villalobos, Judge.
All right. The court has a motion to temporarily amend conditions of bond. State, have you had a chance to review the document?
Just glanced at a hard copy in the hallway, Judge. It appears to be in order, based on the requirement for medical testing. The state has no objection to that basis.
All right. All right, then your motion will be granted.
Thank you, Judge.
You're welcome. Is there anything else?
No, Your Honor.
All right, once you sign the reset form, you're excused. If you want a copy of this, the clerk will be able to get it for you at the back.
Thank you, Your Honor.
You want, before we get into the trial, they want to get to the medical records. Whatever records you might have.
So when did they reschedule this for?
They haven't, we haven't got it court yet, Your Honor. I have to get his school records. So I haven't got that yet.
All right, could you call down to, I guess, Judge Carruthers Court? See if they have any type of setting on this case. It is 2022 CR 11241. So state, I know you're new to this. On this case, there was a plea entered. Then the defense wanted to withdraw the plea. And they're saying there are competency issues. So that's where we are.
Guys, how about the original plea was done? It's all about.
Yes, April of last year.
Correct, Your Honor. And Your Honor, I think I'll state there might be additional discovery. They haven't tendered yet. So she's on the conclusion.
He's claiming that there's body worn camera that state does not have an evidence. I've sent an email to ask if there is any such evidence.
Well, did you all review the
There's
discovery acknowledgement?
There wasn't anything on discovery acknowledgement, Your Honor.
Okay,
On the discovery, I was not the original friend that was assigned to the case, Your Honor.
okay. They don't have a reset date?
The original date they had is for the 17th.
Mhm.
It couldn't go that day, so they were gonna reset it, but I don't have the reset.
All right, so what medical records or school records you're supposed to turn over to them?
The school record, I can't give them honor because I was asked the court. He's on GPS, Your Honor. So I talked to the GPS officer and he told me that he's not allowed to go to the nursing school. So I have to get a power of attorney. I have to go to his house, get a power of attorney, go to the school and get his records.
Yes, that's what I don't understand. Why can't they mail them to him?
I could ask the school.
Yeah. I mean, just pick up the phone, call the school, tell them you would like your records mailed to you. And what documentation do they need in order to mail you your records or to have someone pick up the records?
Yes, sir.
All right, we're recalling this for February 12th. All right, once you sign the reset form, you are excused.
Thank you, Your Honor.
You're welcome. Bashan, Jose Torres has been reset for February 12th.
Thank you, Judge.
All right, why do I have this speed page from all of them?
Defense attorney is asking to approach you on a small question. Just a very quick question.
Yes.
On Maldonado, you got his wife. Me. Obviously, she wanted to get the money effect to be able to run them out. But you won't let her do it. And I told her that's gonna be like a 4 or 5 hour process for you to do. So I told her, let me see if it's what might bring him over and she can bring him down. The power of attorney, and I can get him to sign it.
All right, but with the power of attorney, I think you need, and this is just me.
The document already done, but Joe won't let her do it.
Well, doesn't that have, some part of it has to be notarized or no?
No, that's why I'm saying, the judge won't let me do it. I said, let me see if I can get the court to bring him over. You hire one of those mobile notaries, bring this person to court. You won't be able to talk to him, but I can do that for you and give you the.
They won't let her go to the jail and visit him? Okay.
So I told her, no, I might get a no, but I'll ask.
All right, let me talk to the deputies about this.
And I told her it's gonna have to be on the day when the court doesn't have a busy docket or even in.
All right, okay, let me see what I can do.
Yeah. I mean, do you think the law should allow, what, can you give you a citation in the following 5 minutes? Or so, in the 5 minutes of stuff? I mean, it gets more egregious, right? But I mean, 30 minutes is only 30. I'm just impressed you're able to drop that quick. Right. Well, once again, I said he may have been prior to, he might have gotten a lucky break for first. But at this point, it's like necessity, right? Like, how does it get back? You know, it's a cold storm. It's back to this, like,
I've been in college, it's at a party and got busted. And, okay, we're not thinking.
Because if he doesn't make it by 10:15,
Still there, so.
some people. But also, like, on biggest protection. You know, It's interesting. It's interesting. Yeah, like that. Oh, it's for some, yeah. So it's sort of for, you know, sometimes,
Yeah, I was gonna ask you.
makes some good arguments that it could potentially sway the outcome. Some kind of complete lot of. You know what? They're super nice folks. I like them a lot. I like them a lot. They're not terrible. I used to get a little bit better outcomes. It got a little more. But I mean, like. All the.
It's a thing, right?
It's a problem.
Okay, so round back.
You can turn yourself in, or 3 days deferred. Yeah. Easy. So, you know. They don't want to be, they don't want to kill the goal. It switches to. That's why. I gotta run downstairs. We'll see if you're one. Yes, sir.
Yes, sir.
Mr. Garcia, are you ready on your client? And this is Ernest Mora.
I know.
State on Mora,
Yes, ma'am.
the DWI third, what is the status of that?
Check that.
Defense is saying it has not been indicted.
Good.
All right. It's 2023 9524. And I'm going to give you a reset and then they can take you over quickly.
Yes, Judge, you has to be there by 11:15, I was told.
All right, so I'm going to give you a reset for February 26th. And once he signs the reset form, you're excused. Yes,
Can I ask a question?
yes.
Do I have a reason why my bond was raised? I don't know why.
They'll have to look in the system. I have no idea.
That's what
I feel like it's an error on somebody's part because I've been to court since then and I've complied with everything that they've asked of me.
All right, can you look that up and see for me, please?
Yeah, the reason I couldn't access to give them the answers because since there was a warrant out, I couldn't get into the system to get information.
Oh, we're going to find out right now.
Thank you.
It was a bond increase due to a first violation report of non-enrollment.
All right,
And
so,
that was done through.
yes, so you'll have to talk to Judge Nahara about that. So since you're going to be downstairs anyway, you can speak to him about that. So I'm not the person who did that. It was Judge Nahara.
That was back in November 2023.
Yes,
Judge Moore was sitting on the bench that day.
All right.
Judge Nahara.
but as I understand it, at this point, the warrant cannot be withdrawn because it was already issued. You just have to make the bond, is that correct?
Well, you can call the bondsman and see if there's still a possibility of the bond being reinstated. But before you do that, you'll have to see if they will reinstate the bond at its original amount. But if you're on bond for a DWI, you got to make sure if they want you to have ignition interlock, you got to make sure you have that and everything.
Having all the paperwork, that's what
Okay.
I'm shocked. Like I've been compliant and all of a sudden I get this warrant, which.
Yeah. Well, your attorney can talk to Judge Nahara and see, because as I said, I'm not the one who did it.
Oh, okay.
Okay.
Thank you very much.
All right, you're welcome. Thank you.
Okay.
And Judge, that helps me, but I need to, you did say in there that. I was looking at it, it's no longer with the office, it's been reassigned, so maybe that's part of it.
Okay, all right.
For both cases, you said.
And Bashan, Pete Castillo and Abel Rodriguez have been reset for February 8th. Defense counsel is out ill. And Jonathan Allen is set for February 5th. And Jose Torres, February 12th, and that's for a competency issue.
You blame on the wrong person. We'll talk when we get out.
Dominique Nicholson. Who's the attorney on Dominique Nicholson?
Mr. Nicholson? Right in the middle.
All right. So what are we here for today?
We had sort of a discovery conference.
Mhm.
One of the things that came up last time was the possibility that there's some crime lab information outstanding.
And we confirm that there is not.
Okay.
And then another thing that the state agreed to produce is the criminal history of all the lay witnesses in the case. So they do have some, there's some they still need to get.
Okay.
But otherwise, I think we'll be in pretty good shape on the discovery.
All right.
Part of
So has an offer been tendered?
Yes, Your Honor.
It was,
It's been a while, but yeah.
yeah.
All right. This is what I'm going to do. I'm going to recall this. And I'm going to recall it for a plea deadline date. Now that everybody is assured that they have everything. And on that date, I'll need the acknowledgement of discovery done.
Okay.
And sir, how old are you?
46.
All right. So I'm going to recall this for February 8th. Is that enough time for everyone?
Yes, Judge, for the
Yeah.
deadline date, yes.
Okay.
Yeah,
All right, so we'll be back on February 8th. And that will be your plea deadline date. Do you have any questions about anything? All right. All right. Have a good day.
Thanks, Judge.
This is the moment the courtroom changes. The judge stops being patient. This is no longer a warning. Every word now carries consequences. One wrong move, and freedom disappears.
George Hawkins. All right.
Good morning.
Good morning. All right, where are we on the VA?
Still currently receiving services, Judge. He has his next appointment in February, where they're gonna set him up with counseling. In terms of that, Judge, so he's still working through his treatment. He's doing well, staying consistent with them. We did receive a plea offer from the state today, Judge. They did seemingly take into consideration some of his issues, some of his treatment and some of the issues with the case. So we're gonna speak about his options, Your Honor, if we may have a plea bargain deadline date.
All right.
Hey, Judge, the state was notified that defense may have to be evaluated by the Veterans Court.
That's correct as well, Your Honor. We want to see what kind of options are available for Mr. Hawkins. So I'm going to explain to him the Veteran Treatment Court, and if he qualifies, I'm going to refer him to John Herman so we can.
All right. Vashon, is there any way Mr. Herman can come over? They're gonna have him come down now.
Okay.
All right, and then what we'll do is just approach once he comes down, because then it'll tell me when to set this.
Yes, Your Honor.
So just have a seat and he'll come down.
Thank you, Your Honor. I appreciate it.
You're welcome. Michelle Esquivel. Come forward, Miss Esquivel. Any objection?
No, Your Honor.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? You're charged with the unauthorized use of a vehicle. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? You're going to need to speak up. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Yes. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yeah.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Green, has anyone threatened you, coerced you, or placed you in fear to get you in this, to enter this plea? Anyone promised you anything other than the plea? Satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 14 months in the state jail facility. There are no applications. The state will take in consideration 2024 CR 0731 and County Court Cause number 716842. And there's to be restitution, if any, to Ian, I-A-N, Glenn, G-L-Y-N-N. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
State offer states exhibit 1 in all attachments.
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.